All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Court officer, please call the case.
Good morning, Mr. President, Your Honors. Situation in the Central African Republic 2, in the case of the prosecutor versus Alfred Yekatom and Patrice Edouard Ngai ssona, case reference ICC 0114-0118, and for the record, we are in open session.
Thank you very much. I ask for the appearances of the parties. We start with the prosecution first. Mr. van der Puye.
Good morning, Mr. President, Your Honors. Good morning, everyone. Today, the prosecution is represented by Olivia Straven, Lucio Garcia, Yassine Mosfa, and myself, Kweku Ren. Good morning.
Thank you very much. We turn to the representatives of the victims. Ms. Masida first.
Good morning, Mr. President, Your Honors. Good morning, everybody. For the victims of the other crimes appearing today, Mr. Enrique Carneroyo, at my right. Behind me, Mr. Merwan Chenoufia and Ms. Moira Asso, and myself, Paulina Masida.
And Mr. Seproun next.
Good morning, Mr. President. Good morning, Your Honors. The formal child soldiers are represented by Taisir Otmani and myself, Dmitro Supron. Thank you.
Thank you. I turn to the defense. We start with the defense of Mr. Yekatom. Ms. Dimitri first.
Good morning, Mr. President. Good morning, Your Honors. Good morning, everyone. Mr. Yekatom is present in the courtroom today. He is represented, and I will start with my left-hand side, Ms. Laurence Hortas-Laberge, Mr. Florent Pagès-Granier. We have our visiting professional from Canada, Mr. Simon Ruel. We have Mr. Guillaume Suzuki. Behind me, we have Ms. Alexandra Baer, Mr. Narek Shakalian, Ms. Sabrine Bessat. On my right, Ms. Yusra Lamkadam. On my left, Ms. Anta Gisse. Remotely, with half an hour delay, Mr. Régis Changai, and myself, Mylène Dimitri.
Did you mention Ms. Bayer? I'm not sure. You meant, okay, you did, good. Then we turn to the defense of Mr. Ngai ssona, Ms. Prue.
Good morning, Mr. President. Good morning, Your Honors, and everyone in the courtroom. Mr. Ngai ssona is represented today by Thespina Eleftheriou, Clémence Fontaine, Sorenza Bangaya, and myself, Marie-Hélène Prou, and he is, of course, present in the courtroom. Thank you.
Thank you very much. We all know that we are here to listen to the opening statement by the defense of Mr. Yekatom, and I give the floor to Ms. Dimitri for that.
Thank you, Mr. President.
And with regard to the scheduling, or so to speak, it's no problem at all when you think you have finished a certain topic that you want to address and it's close to 11 o'clock, then we have the break then and we continue afterwards. So
thank you for this. And just before I start, Mr. President, we're going to have a PowerPoint presentation. And just to reassure my colleagues from the other side, the PowerPoint is going to be confidential. It's not going to be displayed to the public, but the entire opening is going to be in public session. Some of the videos, and we've already informed the court officer, are going to be broadcast to the public.
We appreciate that. Thank you very much.
Good morning. It's a privilege and an honor to appear before you today. I first want to thank every member of my team, including those who left us, who worked tremendously hard in trying to investigate, prepare Mr. Yekatom's defense, scrutinize and question all the evidence disclosed by the prosecution, and I could not have done this without them. The team you saw for the past 3 years and the team members you've heard of represent Mr. Yekatom's defense in every single aspect of it. During the next hours, I intend to discuss how the defense case will show that even with basic investigations and diligence, by studying the evidence and paying attention to it, the actual truth is very different to that presented by the prosecution. During my presentation this morning, I will address the crimes committed by uncontrolled civilians. The prosecution, through the trial, presented you with a simplistic approach, trying to convince your honors that if a crime is committed in a certain area where Mr. Yekatom was present, he's automatically responsible for it. The defense evidence will therefore address the crimes committed by civilians bearing this aspect in mind. I will also address the limit of international forces and the crimes committed by some international forces, like FOMAC, which had an impact on who could be trusted to bring back security in the country if those who had the international mandate to do so couldn't. During the presentation of our defense case, we will bring evidence to show that Mr. Yekatom's conduct, as described by the prosecution, did not contribute to the charged crimes. You know the prosecution's case against Mr. Yekatom is weak, but we will present to your honors how he was not part of a common plan to violently target the Muslim population, as charged by the prosecution. The truth is, and you've already heard some evidence to that effect, Mr. Yekatom, a caporal-chef of the Central African Army, the FACA, continued his military duties for some time, even under the Seleka regime, until he fled to Zongo, because he was kidnapped too, like other FACAs. The evidence so far showed, and the defense evidence will show, that once Mr. Yekatom was back in his country, his objective was to oust the Seleka. He did not target the Muslim civilian population, be it in PK9 Mbaiki axis, in Kate, or in Boeing. Mr. Yekatom was not part of a common plan to violently target the Muslim population. There was no common plan in Mr. Yekatom's group. I will address the Lobai prefecture, and more specifically, the PK9 Mbaiki axis and the meeting at the Saint Jean d'Arc Church in Mbaiki. And I will give you an overview of the main defense witnesses who will testify on Mr. Yekatom's message in Mbaiki. I will then address the Boeing Mosque, and by doing so, I will recall the prosecution's evidence on the mosque by comparing it to the evidence you will hear from two main defense witnesses on the Boeing Mosque. I will continue to address the 5th of December by discussing the Catin neighborhood and the Seleka in that area on the 5th of December. And I will then move on to the Boeing market, and more specifically, how defense evidence show that the only two prosecution witnesses on the Boeing market tampered and fabricated evidence that was submitted to your honors. I also intend to give your honors an overview of our defense case on count 29 and present you again with the truth that Mr. Yekatom did not enlist, conscribe, or use children under the age of 15. Despite all the years the prosecution had ahead of us and all the evidence they presented, they were negligent and they lacked diligence also with count 29. They did not take any lesson from the alarming mistake they made in Lubanga, delegating their investigative activities without meaningful supervision. They did not want to test their evidence, and the defense evidence will show that we had to pick up where the prosecution disregarded its statutory obligations. In contrast, the defense case will reveal the fabrication of evidence by a prosecution intermediary and witnesses. Your honors, I will briefly address the context in which the prosecution's investigations led to the case against Mr. Yekatom, as this is at the root of what we say is where the prosecution's theory went wrong. Rather than correct the course of their investigations, as is required of any prosecutorial and investigative body, to take a step back and own where the evidence they collected did not match their case theory, they just pushed on. It is within this context that mistake after mistake was made, and it is such conduct that frames the defense case and will show your honors that the evidence you will hear in the next few months was readily available for the prosecution to investigate and test. After 9 years of investigations, the prosecution closed its case against Mr. Yekatom. But they managed to go from a confirmation hearing with many allegations against him to a trial where those allegations were never presented. I will also address the evidence that the prosecution promised your honors during their opening statement, but nevertheless never presented. As early as March 2013, the prosecution was drawing attention to the situation in Central Africa due to the massive crimes and attacks. The specific situation in Central Africa, starting in August 2012, was referred to the court in May 2014 by President Samba Panza. The prosecution was investigating as early as September 2014, the same month the alleged child soldiers in Mr. Yekatom's group were having an ESF training in Baiki. The prosecution even sent some investigators to attend the Bangui Forum in 2015. They were present as the events were unfolding at a very early stage, and they had 9 years of investigations. They had that luxury. Meanwhile, for some of the evidence presented in this case against Mr. Yekatom, the defense, with much shorter time and much less human resources, were able to conduct due diligence, which raises question about the thoroughness and diligence of the prosecution's investigations. 10 days ago, Mr. Yekatom reached his 5th year of detention. While the prosecution had 9 years to investigate, while they started as early as September 2014, the prosecution was still not ready when Mr. Yekatom was arrested. They asked in February 2019 for a marginal delay to postpone the confirmation of hearing, and they justified that delay on the basis of Mr. Ngaisona's arrest. This led to a first postponement of Mr. Yekatom's confirmation hearing, despite defense objection. In May 2019, the prosecution asked for a second postponement of the confirmation of charges hearing, as if they did not have enough time. But this time, they complained, and I quote, about the unexpected speed at which the suspect were arrested. They were the one issuing an application for a warrant of arrest against Mr. Yekatom, and they complained that he was arrested too fast because they were not ready, despite the luxury of having had many years of investigation. The prosecution is expected to have largely completed its investigations prior to the confirmation of hearings. Your honors reminded them, so did pretrial chamber 2. So you have to ask yourself if the reason for the prosecution to ask for more time is not hiding a reality. They could not find witnesses to support the allegations they intended to present before your honors, and they needed more time to investigate, as they did not have credible and reliable witnesses, and evidence supporting their allegations, their common plan. 9 years of investigations, Your Honors, with a prosecution office that has many divisions, including investigators based in Bangui, in a country office at the heart of the evidence. The defense case will show that prosecution investigations suffered from tunnel vision. They ignored exculpatory evidence. They failed time and time again to meet their obligations towards the defense, most of the time because of their misunderstanding of the materiality of the evidence. They were found to be in violation of their disclosure obligation in this case not less than 12 times. And the email decision issued by Pretrial Chamber 2 last week regarding access to exculpatory material in the Macomb case was also telling in that regard. During their opening statement, the prosecution stated that only systematic conviction of these crimes and abuse will help protect the civilian population. They were not calling for the truth. They were asking you for systematic conviction, a conviction that they wanted so much that it led them into a tunnel vision which guided them through the trial. And we intend to show you how during the presentation of our defense case and through today's presentation. So, Your Honors, let's now go back at the beginning and see how the car situation came before this court. As I mentioned at the beginning of my opening, the prosecution of the ICC made a statement in March 2013 and another one in April 2013, 1 month after the Seleka took power. The prosecution stated that the people of the Central African Republic have already suffered too much. The prosecution was drawing attention to the massive killings against the civilians by the Seleka. The United Nations also called for an urgent need to establish law and order throughout the country and to protect civilians from abuse. You heard the evidence on the Seleka committing mass killings, burning down villages, systematically killing members of the Central African Military Forces, the FACA. You heard how they raped women, pillaged entire communities. You've seen on pictures and videos entire populations hidden, living in the bush by fear of being killed or tortured by the Seleka. And you heard how Mr. Yekatom, a caporal chef from the FACA, who received no special treatment from Bozizé, continued to work even under the Seleka regime. You heard the evidence that at some point they also tried to kidnap him, kill him, and that he fled, but he came back. He came back even though all the officers of the army had fled. You heard witnesses telling you that he came back to oust the Seleka. The prosecution is now charging him with several modes of liability for crimes committed against the Muslim population in the area where Mr. Yekatom was. And I want to pause here for a second and acknowledge the suffering of the Central African people, the Christians, the animists, the Muslims. So for the next few minutes, I will speak in French because I want to have a few words for the people who lived through the events, who suffered, and who are listening from Bangui and elsewhere in CAR. La population centrafricaine a vu des horreurs. Les Centrafricains ont tous perdu des êtres chers. Ils ont vu devant leurs yeux des proches être massacrés. Leurs femmes, leurs sœurs, leurs mères être violées, leurs maisons s'envoler en flammes. Des crimes ont été commis de part et d'autre. Des crimes ont été commis par des gens, par des foules incontrôlables, par des anti-Balaka, par des chrétiens, par des musulmans, par des sélékas, par des animistes et même par des forces de maintien de la paix. Mais aujourd'hui, c'est le procès de M. Yekatom, Alfred Rambo Yekatom. Aujourd'hui, c'est son procès et non le procès de tous les anti-Balaka, de tous les groupes d'autodéfense, de tous ces gens qui ont pris des armes. Et pourtant, le procureur l'accuse de tous les crimes commis dans Boeing, dans Catin, dans l'Obaï, sans identifier spécifiquement les responsables. Le procureur simplifie la crise centrafricaine en tentant de convaincre les juges que c'était anti-Balaka contre musulmans, séléka contre chrétiens. C'est une vision bien simpliste d'une situation complexe. Et ce n'est pas rendre justice aux victimes que d'accuser et de condamner une personne qui n'est pas responsable de leur souffrance. Le procureur, tout au long du procès, blâme M. Yekatom, qui est assis derrière moi. Il l'accuse même lorsque des civils incontrôlés commettent des crimes contre les musulmans, même lorsque des jeunes s'autoproclament anti-Balaka et commettent des crimes contre les musulmans. M. Yekatom n'avait ni la responsabilité ni le contrôle de toutes les personnes qui n'ont pas pu contrôler leur colère et qui s'en sont pris aux musulmans. Pour chaque crime commis contre les civils musulmans, le procureur a le fardeau de prouver, hors de tout doute raisonnable, que M. Yekatom a la responsabilité de ce crime et l'intention de le commettre. Même les forces internationales étaient impuissantes face à la colère incontrôlée des non-musulmans, qui avaient vécu 9 mois de souffrance indescriptibles et inimaginables. Alors comment peut-on demander à un homme comme M. Yekatom de dissuader tous les individus qui se trouvaient dans les lieux où il était? Et entendez-moi bien, il ne s'agit pas ici de présenter M. Yekatom comme un sauveur. Et vous n'avez même pas à penser que M. Yekatom est un homme sympathique. Mais vous avez entendu la preuve à l'effet qu'il a quand même, à sa façon, tenté de dissuader les civils de commettre des crimes contre les musulmans. Et vous allez entendre des témoins de la défense vous décrire comment il a tenté de protéger les musulmans contre la hargne des civils. Et je vais maintenant revenir à l'anglais. The hatred of the civilian population, the lynching of the Muslim civilians by civilians is my next topic. And it's an important one, because through the defense case, you will hear evidence that not only Mr. Yekatom was not part of a common plan to target Muslims, but he intervened time and time again to stop people who had no link with, who he had no link with, civilians, angry civilians who wanted to harm Muslim civilians. The hatred of the civilian population kept growing, and it divided communities. Defense witness 5014 will talk about it. She will mention how she had to dress up to dissimulate her faith. How difficult can it be for someone to deny their own culture, their own tradition, their faith by changing their religious clothing appearance in their own country to avoid being attacked? She will mention how neighbors threatened her because of her faith. and she will mention how Mr. Yekatom saved her and how he helped other Muslims as well. You have seen it on a number of videos, and our defense witnesses will testify on some of them as well, as we intend to show you the chaos, the hatred of the non-Muslim civilian population. And our defense witnesses will also describe how the uncontrolled civilians became towards the Muslim population. You heard former Prime Minister Ngai telling you that the country was in a situation that was out of control, and how, and I quote, very difficult it was to have a handle of these people, meaning the civilian population. You heard it from President Samba Panza, telling you there was no state, no justice, no army. It was total chaos. You heard President Samba Panza calling for her FACA. She needed her FACA. She needed law and order. She fought against the mesures de confiance. She wanted her FACA and interior security forces to be armed. Why? Because otherwise the chaos would continue. Why? Because the international forces were insufficient. Because they couldn't depart from the main roads. They didn't go in the inside of the country. And remember, Lobai is in the inside of the country. In fact, she says it was even less secure in the inlands. So when prosecution uses crimes committed in a location where Mr. Yekatom or his group were, the evidence has to be scrutinized. Remember how the prosecution showed you during their opening statement a small video from the 7th of December 2013 in a small village with houses all around. And on that video, you could hear people say, "This is our country, not that of the Muslims." You cannot distinguish the identity of the speakers. No evidence was brought by the prosecution to show that they were members of Mr. Yekatom group, those speakers. The video Your Honors will have on your screen in a second is also part of the defense evidence, because you always have to keep in mind how uncontrolled the civilians were.
A nation at the very heart of Africa, a heart poisoned by religious hatred and torn apart by violence. Today, Christians loot shops owned by Muslims.
La población civil. La resolución también permite imponer sanciones contra los líderes de los grupos a los que se acusa de perpetrar masacres y violar los derechos humanos. Este mismo martes, soldados de la misión de paz africana que opera en el país trasladaban a ex rebeldes de la coalición islamista Seleka. Los enfrentamientos entre las milicias musulmanas y cristianas han dejado miles de muertos y casi 1 millón de desplazados. La ONU calcula además que se necesitan al menos 10.000 cascos azules para garantizar la seguridad en el país.
The images you just saw should be kept in mind at all times when the prosecution is alleging crimes committed in an area where Mr. Yekatom was. The situation at the time in Bangui, in the hinterlands, was much more complex than to simply say that the perpetrator must belong to Mr. Yekatom's group because the crime was committed in the Lobai, or in Boeing, or in Catin. Every incident alleged by the prosecution that led to the fear and displacement of Muslims must be analyzed with precision. The defense should not have to disprove every allegation. The prosecution bears its burden at all times. and the prosecution is seeking to blame Mr. Yekatom or Mr. Yekatom's men for any alleged crimes that occurred in the Lobai or Boeing, and that if a crime happened in the Lobai, then it must be Mr. Yekatom's men. But this approach ignores the reality on the ground, and this approach ignores the videos you just saw. The widespread violence against Muslim civilians by the population cannot be ignored. And in addition to that, and this is what also the defense case will show, small anti-Balaka groups everywhere throughout the country were present, such as the video your honors will have on your screen. There were various anti-Balaka groups that had nothing to do, no links at all with Mr. Yekatom. Defense witness 1989 will also testify about the presence of a different anti-Balaka group coming from another area and committing crimes in the Lobai. All these unknowns, all these unidentified perpetrators committing crimes against the Muslim population should be enough to raise reasonable doubts when it comes to Mr. Yekatom and the area the prosecution claims was under his control. Because in reality, at the time, chaos was not allowing a lot of control. It was a crisis situation. We will present you with a December 2013 video, which is on our defense list of evidence, and which shows what many witnesses testified so far, and which also support what defense witnesses will testify about. The helplessness of the limited gendarmes in Bangui, facing a non-Muslim population that was so uncontrolled that they didn't even fear the consequences of committing a crime in front of law enforcement, such as the video your honors now have on your screen.
Pris à partie. Des gendarmes centrafricains s'interposent pour empêcher un lynchage.
And let's not forget another important reality that also played a role in the suffering of the Central African people. The fact that some of the international forces who had the mandate to bring back peace and security were in fact doing the exact opposite, such as the video you will now see on your screen, and which is also part of the defense list of evidence.
tchadien qui a tué tout le monde ici à Bangui. Il dit que ici au Gobongo, il va tuer tout le monde ici. Les faux macs tchadiens qui a fait ça. Les faux macs tchadiens. Ça fait même pas marcher. Y'a quoi, c'est moi.
You saw the FOMAC creating chaos, killing civilians, creating fear and despair. How can you ask someone in that context to accept that only the international forces can be armed, as they are the one with the mandate of bringing back security? How can you charge someone like Mr. Yekatom for keeping his FACA military equipment? And the defense case will explain the reasons behind the lack of disarming.
Actually, Mr. van der Poel, it's now the hour of Ms. Dimitri. I don't want an interruption. Please. Yeah.
Thank you, Mr. President. I just take note of our email from earlier, please.
Yes, and we have, of course, taken note of it, but I don't see any, let's say, reason at the moment to interrupt here. So, Ms. Dimitri, it's your time and your hour, so to speak. Please continue.
Thank you, Mr. President. I appreciate it. For what purpose did he keep his equipment? He wanted to liberate the country from the Seleka mercenaries. You heard prosecution witness 1839 say it. L'objectif, au-delà de toute chose, était de libérer le pays. So during the defense case, you'll hear that through his attempts to re-establish order, he tried to protect the civilians. He went in the Lobai. He re-established checkpoints that existed before. He went and tried to fetch the gendarmes and interior state authority to re-establish order, to secure the population. What the United Nations had asked as early as April 2013, law and order. What President Samba Panza was not able to do because the international community was limiting her, controlling her. You will hear the evidence of defense witness 5015. He will explain how Mr. Yekatom's intention was to bring back security and peace. Defense witness 5015 will explain how some international forces like MISCA were sending Mr. Yekatom in small villages to fulfill their mandate to bring back security and peace, because they could not do it themselves. Did the prosecution understand that? No, because they ignored the exculpatory evidence from the outset, and they held on their common plan. They're charging Mr. Yekatom through an essential contribution for ordering his elements to commit the charged crimes, as well as leading, training, equipping them, and structuring them. But remember what President Samba Panza said: a country cannot live without its army. So there was no common plan for Mr. Yekatom to target the Muslim civilians. So you can't charge him for structuring, training, and equipping his elements when his goal, which you'll hear during the defense case, is to oust the Seleka and mercenaries, to try bring back peace and security for civilians. It's that same equipped and trained Mr. Yekatom who saved defense witness 5014 and her family from being lynched. You will hear, Mr. President, Your Honors, from defense witness 5014, who will confirm that as early as December 2013, Mr. Yekatom was telling individuals out of control not to harm the Muslim population. She will describe how she was so scared of the non-Muslims who were ready to lynch as many Muslims they met on their way. But the prosecution keeps insisting that Mr. Yekatom was part of a common plan to violently target the Muslim population, that Mr. Yekatom and members of his group espoused and participated in a plan or agreement to violently target the Muslim civilians in Bangui and Lobai. The defense case will show that not only Mr. Yekatom did not espouse or participate in any such plan, but that such plan did not exist. Your Honors have already seen contrary evidence from a range of prosecution witnesses, but you'll hear more from defense witnesses. I cannot talk about the common plan without saying a few words about Maxime Mokom, whose charges were dropped by the prosecution. Maxime Mokom, who according to the prosecution was a subset of this trial, because him and Mr. Yekatom were both apparently linked through the prosecution's so-called strategic common plan and operational common plan. The prosecution was alleging that Mr. Yekatom picked himself weapons from Maxime Mokom in Zongo. That part of the prosecution's case collapsed. During the course of the entire prosecution evidence, there was no evidence at all of Mr. Yekatom obtaining weapons and ammunitions from Maxime Mokom in Zongo, nor that he himself picked up ammunitions from Mokom in Zongo. You will also recall a notebook that was relied upon by the prosecution to support the links between Mr. Yekatom and Mr. Mokom. The phone book that Your Honors now have on your screen contains the name of Mr. Yekatom and a phone number next to it. The defense evidence will show that this phone number did not belong to Mr. Yekatom at the time. It belonged to Marius Einer, as you can see from the defense evidence on the top right of your screen. Marius Einer being an element of Basile Beaumont. This piece of defense evidence that's on the top of your screen comes from Orange Telephone Company. It was easy to obtain. Our team simply sent a cooperation request to the Central African Republic asking who was the holder of that phone number at the relevant time. And they responded. But the prosecution could have done the same. From day one, the prosecution was relying on telecommunication evidence in this case, with a table of phone numbers and phone calls annexed to their document containing the charges. They sent numerous requests for cooperation to obtain phone numbers, phone data, phone calls, or to ask under which name certain phone numbers were registered on. How could they have neglected to check this one? A notebook allegedly belonging to Maxime Mokom, against whom they had filed an application for a warrant of arrest, and in that notebook, a phone number allegedly belonging to Mr. Yekatom, against whom they had also filed an application for a warrant of arrest. A basic step when sending all those requests for information to obtain a phone number attribution would have been to test that simple piece of evidence. The prosecution also failed to show the links between the strategic common plan and the operational common plan. They promised you a number of witnesses who would talk about how Mr. Yekatom participated into high-level meetings with the Anti-Balaka National Coordination. And they had alleged that there was, from the start, one single anti-Balaka group. You heard the evidence. They had it wrong. As a number of witnesses explained, it was not the case. But I will not dwell on this further. So now that the parenthesis on Mr. Makom is closed, let's come back to the non-existence of the common plan against Muslims. During the period of the charges, Mr. Yekatom spoke out against violence against the population. You'll recall the evidence of prosecution witness 1595, who specified on his own, during his familiarization process, when he was rereading his statement, he added a sentence, and the sentence said, "On ne doit toucher à aucun musulman, ni à aucun imam." And according to him, Mr. Yekatom had said those words. And he added that Mr. Yekatom stated during the gathering in Baiki, and I quote again, that Mr. Yekatom came against Chutodia and his elements, and since they had gone, he would not harm anybody. He went further, and still at Saint Jean d'Arc meeting, he said that Mr. Yekatom started saying, "You, the Muslims, I have no problem with you. When I was young, the Muslims took care of me and educated me. I only have problems with Jotodia, but he has already left." And another prosecution witness, 2041, added about Mr. Yekatom, "Il n'était pas là pour combattre les musulmans, ni pour détruire les mosquées, ni pour s'en prendre aux biens des personnes." You've seen the evidence. You've heard it. From insiders like prosecution witness 1839 to Muslim civilians who either testified publicly or with protective measures. Mr. Yekatom was specific not to kill the Muslim civilians that were not armed. He was against the Seleka, not against the Muslim civilians. The prosecution's case was that when Mr. Yekatom progressed towards the Mbaiki axis, he had established checkpoints to regulate movements and target civilians. You will hear from defense witnesses that Mr. Yekatom did not come into the Lobai to harm the Muslim civilians or the imams. He came to chase the Seleka. And before I describe the defense witnesses that will come and testify about the PK9 and Baiki axis, let me just remind your honors that you've already heard it from prosecution witnesses, including 6 Muslim civilians who came and testified themselves about Mr. Yekatom's intention and objective. Many of them spoke about the Saint Jean d'Arc meeting, which is my next topic. Many of them spoke about the message Mr. Yekatom gave and how he called for the civilians to be protected, Muslims and non-Muslims. And this is what the prosecution said during their own opening statement about that message. That Mr. Yekatom was not sincere, that his message was hollow, that his words were a sham. Of all the several prosecution witnesses that you were promised, not one made such an allegation. In fact, 12 prosecution witnesses testified about the Saint Jean d'Arc meeting, among them half of which were Muslims. And this is what they said: that the aim of the meeting was to get organized in order to protect the Muslims and the Christian population, the entire population. And it was not only his words, his conduct, that also had a positive and concrete effect. As some of the prosecution said after Mr. Yekatom's speech, that subsequently there were peace and there was calm. And had he not given his speech, then it's quite sure that there would have been a very tricky conflict. And not only did the prosecution never bring any witness to say that Mr. Yekatom's message was hollow or not sincere, but even one witness testified that in private, Mr. Yekatom really cared about Muslim. Prosecution witness 2353 said that Mr. Yekatom told him he should not leave the country, not to go in exile. So since the prosecution brought many Muslims who confirmed Mr. Yekatom's real intention not to touch the Muslim population, we will present your honors with other key figures of the Lobai to explain all the circumstances surrounding the evacuation of the Muslim population in Baiki on the 6th of February 2014. And to demonstrate to your honors how an important part of the Baiki history was missing from the prosecution's narrative, I want to go back in time, back to Mr. Yekatom's warrant of arrest. Although the prosecution never agreed to share with the defense the application for Mr. Yekatom's warrant of arrest, which is a first in the history of the ICC, we nevertheless know that the 2018 application for warrant of arrest included a reference to the Mbaiki meeting at the end of January 2014 with Bishop Reno. In fact, the prosecution learned of the existence of what will become a key figure in Baiki, Bishop Reno, as early as mid-2017. Not less than 11 prosecution witnesses mention Reno one way or another in their statement. 10 of those prosecution witness statements that are now up on your screen mention Reno's role in the Baiki meeting. So nobody can ignore that Reno was an important religious figure in Baiki and part of the so-called January 30, 2014 meeting where the evacuation of Muslims population in Baiki will be discussed, which is also part of Mr. Yekatom's charges for displacement and forcible transfer. Regardless, and despite 9 years of investigations, the first time ever the prosecution asked to meet Reno is when the defense announced him as being a defense witness on its preliminary list. We do care for the truth. We do want you to hear from witnesses who were present at the time. So your honors will hear from Reno in less than 2 weeks. He will describe Mr. Yekatom's words and behavior and Mr. Yekatom's collaboration with Miska. He will explain how when the Seleka left, the non-Muslim population saw it as an opportunity for revenge. He will explain and testify that the Muslim population converged to Mbaiki by fear of what would happen when the Seleka left, and how they were afraid to try to take revenge, that people would try to take revenge. Bishop Reno will speak about the meeting of 30 January, where Mr. Yekatom presented himself as a caporal chef and said that he was not an anti-Balaka. Mr. Yekatom expressed that he worked to protect everyone, not a particular community, and that he had no negative sentiments towards the Muslim community. He will also describe that thugs present in Baiki were threatening peace and security, and how he asked Mr. Yekatom to go speak in public to bring back order in the city. You will also hear from another key figure in the Lobai region, defense witness 5013, who was part of the Danish Refugee Council, DRC. The DRC was also mentioned by several prosecution witnesses. The key role of DRC in the Lobai and more specifically in Baiki, was highlighted by the Préfet of the Lobai, Alexandre Kouroupeaou, in a contemporaneous video that Your Honor is going to have on your screen. And before you hear him speak about DRC and their role in the Lobai and in the security meetings, remember, the prosecution had that video in their possession since 2016.
Deux, une tentative de réconciliation au point d'être célébrée entre les Séléka et les anti-Balaka venus de Bangui, préparée la main dans la main par le HCR, le DRC, la plateforme interreligieuse et le préfet, a été transformée en réunion de sécurité le 30 janvier 2014.
He's speaking about the 30 January meeting and about the role of DRC. Defense witness 5013 was part of the protection cluster for DRC. Had the prosecution been thorough, they could have met her to seek her recollection of what she witnessed in Baiki and in Lobai. In fact, Your Honors, they did meet her as early as November 2016, but no questions were put to her regarding Mr. Yekatom's charged crimes. In any event, she's among the defense witnesses that we intend to present, and she will explain the meeting at Saint Jean d'Arc Church in Baiki, and more specifically, how she asked Mr. Yekatom to go talk to the local population outside of the church to calm them down, because there was no state authority to do so. She will echo the words of Mr. Yekatom, who addressed the crowd, saying that they should not be here, as this is a matter for the military, and that they should go back to work in the fields or at school. While the prosecution is still trying to convince you beyond a reasonable doubt that Mr. Yekatom is criminally responsible for the displacement of the majority of the Muslim population along the villages of PK9 Baiki axis, notably by threatening or harassing Muslims in the region, we will present evidence showing that Mr. Yekatom was not threatening them or harassing them. Mr. Yekatom was in fact trying to save them from people already present in Baiki. The prosecution claims that Freddy Wanjo, Cœur de Lion, was a member of the alleged common plan. You will recall prosecution witness 1962's evidence, which was also quoted by the prosecution during their opening statement. And they said the following about prosecution witness 1962, and I quote, Cœur de Lion didn't hide the fact that he wanted to chase the Muslims away. I heard him saying it. And he added, Cœur de Lion had chased away the Muslims from PK9 to Mbaiki and all along the road to Boda. Now that same prosecution witness, 1962, testified that he had got this information when he had accompanied Cœur de Lion and a number of his elements when they traveled from Baiki to Boda to join the fighting in February 2014. It is the defense submission that prosecution witness 1962 fabricated this account. He never participated in this trip to Boda, and therefore he never heard Cœur de Lion or his element saying anything of the sort. This should be clear enough from the trial record as it currently stands. For instance, from the fact that he wasn't even able to recognize Cœur de Lion when was shown a photograph of him during his testimony, or from the evidence of the two prosecution witnesses who were in fact on that trip to Boda, prosecution witness 1786 and 1647. But I'm not going to go into detail at this stage. During our defense case, however, we will call additional evidence to prove that 1962 fabricated this account. Your Honors will recall that 1962 made reference to an individual who was involved in gathering Faka from Boda in Bangui, with the aim of having them return to Boda to defend the city, and that meetings were organized to this effect on the eve of their travel, first to Mbaiki and then to Boda with Cœur de Lion and his elements. Now we met the individual in question. It's defense witness 3014. And we intend to rely on his witness statement as part of our defense case. And in this statement, he refuted several key claims of prosecution 1962 regarding the organization of this trip to Boda. And defense witness 3014 contradicts other falsification of 1962. For example, his claim to have worked alongside Mr. Yekatom in the mines of Boda, or his claim to have grown up with Mr. Yekatom in Boda, all seemingly peripheral lies, which in fact were fed to the prosecution's investigators to embellish his statement for relocation purposes, by falsely implying that he knew Mr. Yekatom well and to lend credibility to his broader claims. And again, defense witness 3014 wasn't hard to find. Like prosecution witness 1962 told the prosecution, he was a public figure. Again, we submit that the prosecution simply didn't wish to test its evidence. Even with its own insider witnesses, 1647 and 1786, whom it knew were on this trip to Boda, that 1962 claims to have participated in. We've explained how the prosecution did not, after their 9 years of investigations, hear from witnesses such as defense witness 5015, 5013, or 3014. We submit that a similar pattern appears to have been applied for the 5th of December attack and the Boeing Mosque, which will be my next subject. The statement of prosecution witness 1339 was an important part of the prosecution's opening statement against Mr. Yekatom. The prosecution quoted it and said that prosecution witness 1339 would come and testify that, I quote, "We used rocket and grenades to destroy the walls of the mosque. We burned the roof using gasoline and matches. I saw people with canisters of gasoline bought in Boeing." One witness was supposed to testify on this. Only one. 9 years of investigations and one witness only. And I want to rewind on a point I made earlier because it's an important one. Remember, the prosecution asked for more time before the confirmation hearing. They got it twice. And still, they fail to bring a single witness to corroborate 1339 because he had lied about it. Not because the prosecution didn't have enough time to bring witnesses to corroborate him. Not because nobody witnessed the destruction of the mosque and how it was destroyed. Because we, our defense team, found people who did see the destruction of the mosque. And these are defense witnesses 4011 and 4013. The prosecution even visited the area where the mosque was as early as 2016, 7 years ago. and they took GPS coordinates, as you can see from the image on your honor screen. And they went again in 2020 with prosecution witness 1528, and they took again GPS coordinates, as you can see from your honor screen. And this time, they took a video footage, who's on the right-hand side of your honor screen. Some of our defense witnesses will testify on that video screen. The prosecution was there, on the field, a few meters away, next to several houses of people living next to the mosque. You can see from that video screen the residential area surrounding the mosque. The prosecution had time, they had the facilities, they had the means, and they went there. And they were never able to bring you a single witness to corroborate their insider witness, 1339, who described this horrific destruction of the mosque, supposedly watching it burn down. Not even satellite imagery corroborates this account. You heard the expert, the satellite expert, in response who said, and I quote, "I would expect more debris to be visible if there was explosive being used like that. And you wouldn't see the roof 100% gone." But the defense went there. It's not far. It's next to the airport. I went there. Mr. Changai went there. And we walked around. We did the basics. Meet the direct neighbors of the mosque. And what will they come tell you? That it was destroyed by hand. The population, not Mr. Yekatom, the population pillaged it, removed the nails, removed the metal roof. There was no rocket, there was no fire, and it didn't burn down. So you'll hear the description of the destruction by defense witness 4011 and 4013. They didn't see a rocket and they didn't see it burn down because that never happened. And that's why prosecution witness 1339 was never corroborated. And that's why prosecution 1339's story is inconsistent with the accounts of defense witness 4011 and 4013. But remember, the defense witness's testimony is consistent with that of prosecution witness 2682 and 0884, who also said that the bricks were removed little by little and that the roof was taken away by hand, no rockets. And when you hear the testimony of defense witnesses 4011 and 4013, you will understand. You'll understand why the prosecution expert said that what he saw on the satellite imagery was not consistent with the rocket, as you wouldn't see the roof 100% gone. Defense witness 4011 and 4013 will explain how the roof was removed. And you will understand why there were no debris of the roof seen on the satellite imagery. And why on the satellite imagery the roof was 100% gone. Because defense witnesses will explain in detail how locals removed the roof with their hands, with nail pullers, not with a rocket. The prosecution missed another basic, important exculpatory material, contemporaneous videos in the prosecution's possession depicting the 5th of December early moments. The 5th of December attack. What did they tell you? That Mr. Yekatom was responsible, that he displayed the population of Boeing and Catin to Piquet 5. So we had noticed that a certain prosecution witness had videos of the 5th of December. So we asked for them. I mean, the main event in this trial is the 5th of December attack. So the least we could do is to have a look at those videos. So we asked for them. The prosecution first said they don't fall under Rule 76. And then they said they're irrelevant. So we negotiated for 8 months. Was told that the videos went through a review process but deemed irrelevant. But finally, after much persistence, we got them. So let's look at those videos that the prosecution did not disclose for months while Mr. Yekatom was suspected for crimes committed in Catin and Boeing.
No, Mr. Van der Poeje.
Mr. President, there is an established and normal scope for an opening statement which attends to the evidence the defense intends to put. I've sat here patiently listening to argument on the facts, argument on the law, now even argument concerning disclosure process. I would ask the court to advise counsel to stick to the appropriate scope of an opening statement, which is the evidence the defense intends to introduce in response to the prosecution case.
So, well, please, Mr. Van der Poeje. The chamber is aware of the purpose of an opening statement. The situation here that we have is that we had already the prosecution case, and that is a situation that cannot be compared to an opening statement that is given at the beginning. Ms. Dimitri consistently and constantly puts forward and mentions the witnesses that that she is going to present, and of course she is going to present that in front of the background, so to speak, of what has already happened. So this is in the nature of events. The defense counsel is not very nice to prosecution. That is part of the game too, sort of, and I fully understand that you don't like it, and perhaps Ms. Dimitri, you could tone a little bit down, but in principle it is still in the purview, still in the framework of an opening statement at this specific stage. So and let's not forget, and for everyone, also for the audience, opening statements are not evidence. We should not forget that. The evidence by the defense will be presented in due course. And Ms. Dimitri, on that, please continue.
Thank you very much, Mr. President. So let's look at those videos that are on the defense list of evidence and that the prosecution did not disclose for months while Mr. Yekatom was suspected for crimes committed in Catin and Boeing on the 5th of December. And before we look at those videos, there's a reason why we put them on our defense list of evidence. Because after we got them, after our first review process, it was obvious to us that they were highly relevant to this case because they show the Seleka on the 5th of December in the neighborhood of Catin. So let's watch them, bearing in mind Mr. Yekatom is charged with displacement of the Muslim civilian population in the neighborhoods that you're going to see on those videos on the 5th of December.
Filmez ce type-là. On va prendre une petite... Filmez.
Moral, moral, moral! Moral! Aïe! On va nettoyer propre! Moral!
This is what they showed. The Seleka in Bangui. But where? In Kata. Randomly shooting on everything that moves. Clearly, the prosecution had failed to understand what was really happening in Boeing and Kata that day, even though it was obvious from now the image you have on your screen that this was Kata area. The fact that the prosecution didn't recognize these videos as relevant, let alone exculpatory, shows the degree to which the prosecution had failed to understand the reality on the ground during the crisis and the charged events. But defense witness 4011 will come and explain how the door-to-door killing by the Seleka made them flee. Defense witness will testify about what the Seleka were doing, causing civilians to flee. You've already heard part of it from the prosecution's case, the Seleka indistinctly shooting on everyone and everything. In addition to the uncontrolled civilian population, it scared off the civilians, the Christians, the animists, the Muslims, who all had to abandon their house and who fled. Prosecution witness 2475 was also part of the prosecution's narrative for the 5th of December. Like prosecution witness 1339, he also claimed he was present, but both accounts are irreconcilable. I'm going to recap in a very few words on how both witnesses are irreconcilable before moving to the defense witnesses against them. Prosecution witness 1339 claims that there were no women during the attack. 2475 says the opposite. 2475 claims that there were many children during the attack. 1339 says there were no children in the group at any time. 1339 said that the group stayed together on the 5th of December attack and that they only split at the fundamental church in Bangui. 2475 said that they split and lost track of Mr. Yekatom before entering Bangui. 1339 says that over 750 people participated in the Boeing market attack. 2475 says that there were less than 50. And more importantly, 1339 says Mr. Yekatom is present at the Boeing market during the attack. 2475 says he was not. 2475 says the only person with a firearm was Coeur de Lion, and 1339 initially claimed that 611 firearms were distributed to those elements who were heading towards the market. 1339 says the Muslim traders were armed. 2475 says they were not. As your honors know, and as will be developed later on, the defense uncovered an extensive network of fabrication of evidence on count 29. And the fabrication of evidence was not limited to child soldier, but it was also used by prosecution witness 1339. Key to the prosecution's narrative for the 5th of December attack, who also benefited from relocation. The prosecution insisted that witness 1339 would talk about the administrative structure of Mr. Yekatom's group, and that Mr. Yekatom would have been assigned with a secretary to maintain the group's official record. And he had given a notebook to the prosecution, claiming that that notebook was written by someone before the 5th of December 2013. The prosecution neglected to look at the basics. It was there, in their hands. The picture on the notebook was a famous football match of 2014, which is now in our defense list of evidence. And it's now on your screen. That image on the notebook on the right-hand side of your screen was so notorious that even you, Mr. President, commented on it. So the notebook could not have been written in 2013. You nevertheless asked the witness various questions to see if there was any plausible explanation to provide the prosecution a notebook with a picture of 2014, although written supposedly in 2013. But prosecution witness 1339 insisted. He got caught in all sorts of contradictions. He claimed the notebook was written in 2013, but that it was bought with the image on it in Baiki, which of course was not possible, because given that picture, the notebook could not have existed in 2013. It had to be issued and on the market late 2014. But there's another reason why your honors shouldn't rely on any of this evidence on the 5th of December. And it's the evidence you will hear from defense witnesses. Defense witness 6018 and 6036. Prosecution witness 2475 claimed to have entered the group before June 2013. I won't say it in public, but June 2013 was a key moment in that individual's life. He claimed he spent 6 months with the group prior to the 5th of December, and that he was kidnapped and nobody could leave the group once in it or they would be killed. Both defense witnesses, 6018 and 6036, will say that prosecution witness 2475 was in Lobai, living with his family, doing activities with his friends, doing little jobs, and attending an important event, a wedding. So, if your honors agree, Mr. President, I could break now, and after the break, move to the topic of the evidence fabricated in this case, which involves many witnesses, starting with prosecution witness 2475.
Yeah, that's no problem. I think we have a break now until 11:30.
All rise, please,